Welcome to Salty Esquire. My name is Chad Ropes. I'm a licensed attorney in the state of California and your host for this show. Today's topic: child custody battles in California and the family court system. Why you should stay away. Let's get started. How does a parent end up in the family court system? Well, the most common way to do it, there's two ways. The first, and this is probably the most common, is you go through a divorce. Generally speaking, when you file for a divorce and you have minor children, there will be some form of child custody issue. Second way is what we call a paternity action. This is where a child is born out of wedlock. The parents aren't married. Usually, father files an action to determine that he is the legal father of the child. Sometimes mom will go ahead and do that, trying to determine if father is the legal father of the child. The third way that sometimes people can get into a child custody issue in family court is the filing of a domestic violence restraining order. If there are minor children involved, through the restraining order, a parent can get child custody orders. Now, this one is secondary because many times after a domestic violence restraining order is filed, the parties also go through either a paternity action or a divorce or dissolution action. There are two types of child custody in California, and all these rules are governed by the California Family Code. So, the two types of custody. First, there is legal custody. Legal custody is which parent gets to make the major life decisions for the child. These usually include education, healthcare, religion, sometimes some extracurricular activities. So that's legal custody. Who gets to make the decisions? It can be either joint, both parties are sharing in the decision making, or sole, meaning one party has the ability to make the decision on their own. The second type of custody is physical custody. It's just what it sounds like. Who physically has the child in their care and for what period of time? It is very common to have joint legal custody. Generally, the courts want to ensure that both parents have decision-making ability for their children. It's a little different when it comes to physical custody. So how is the court going to determine which parent should have physical custody of the child and for what period of time? Well, the Family Code helps us in this also. There are provisions in the Family Code that say the court needs to determine what is in the best interest of the minor child. We call that the standard. So the court needs to determine what's going to be best for these children or child. So what does that mean? Well, there are numerous factors that can fall under what is best for these children. Some of those factors: stability and continuity. What is that? Children need stability in their life. Stability, understanding what's going to happen in the future, having some habit, having a schedule for the children. Stability can also include living in the same residence, having the same room, going to the same schools, having the same healthcare provider, or going to the same church. These are all issues that the court can look to for stability and continuity. Which parent is going to provide for the health and welfare of the child? Does either parent have an alcohol, drug, or mental illness issue that could affect their ability to care for the child? Is there domestic violence going on in either party's household? the courts want to protect children from both physical and mental violence. So those are some of the factors that the court will look to in determining what is in the best interest for the children. I started with, you should stay away from family courts. So let me explain to you why I have that opinion. I've litigated hundreds of child custody cases. Generally speaking, the courts do not have enough time to properly hear all of the cases that are filed. For every hour of court time available, there is probably 10 hours of time that the litigants need to get their cases heard. So there's not enough time. So what do the courts do? Well, they've had to limit how much time parties are going to spend on cases. Now, they don't do this systematically. They don't tell you, hey, you only have 5 minutes for this case. But every judge knows if I have 50 cases on my docket and I only have time for 10 of them, I'm going to have to make up that time in some way. So in general, the courts are impacted. They don't have enough time to properly hear all the cases. In addition to that, the judge doesn't know you. The judge doesn't know what kind of background you have, what happens in your life on a day-to-day basis, what type of issues your children are dealing with. The only thing the court knows is what you provided to them, usually in a couple pages of a written declaration and maybe in about 15 minutes of testimony. Generally speaking, that is not enough time to properly analyze what's happening in a case. Lastly, this is my opinion. I believe parents should decide what's right for their children. Not third parties, not some man or woman wearing a black robe, not a government employee, parents. Take care of whatever issues you have with your children outside of court, between the parents, so that you don't have to go through this process. If you found this information interesting, if you disagree with my assessment, please leave a comment. If you enjoyed it, hit the subscribe button so that you can be notified of future episodes. But most importantly, remember, when it comes to legal issues, take everything you hear with a grain of salt.